how you want to start this? Want us to go around the room and everybody introduce themselves for the record?
Sure.
Okay. JD, why don't we start with you?
John Upton, Public Safety.
Lorraine Hudson, Clerk Finance.
Nikki Powell, Clerk Payroll.
Kristen Huell, County Attorney's Office.
Janice Gilly, Administrator.
Ed Spanauer, Human Resources.
Jimmy Madry, Interim EMS Manager.
Carlos Arana, Chief Steward, IAEP.
Thomas Jackson, Vice President, IAEP.
Dick Anderson, Chief Negotiator for the IAP.
Michael Morosco, National Representative, IEP.
Renee Butler, IAP Secretary.
Okay. All right.
I guess we should have a sign-in sheet.
Probably a good idea.
Yeah.
I can grab one.
They got a piece of paper right there. We'll start with that.
We need one on here. What would you like on here? Oh. Name.
AEP negotiations, yeah.
Name and title.
Checking account number. Social.
Top of 6. So how would we like to begin?
Well, it's been since April, since we last met. Obviously, some significant turnover on, in the county government.
Yes.
So it probably wouldn't be a bad idea to make sure, because when we did meet on April 9th, we gave you 2 proposals. The county had some proposals that they gave to us. We gave you counters to those proposals, and the last thing that we talked about was an issue that had been ongoing for a while, how to implement the Evergreen study, which, revealed a disparity in the wages paid to the EMS folks here and in the counties that the study surveyed. And my notes reflect that Eric Kleiner, who was here at the time, said the Board of County Commissioners was working on how to implement that study. So we did not, we didn't exchange proposals on wages because we were still waiting for the Board of County Commissioners to figure out how they wanted to deal with the implications of the study. So I suppose from our perspective, we'd like to know if any progress has been made on that issue.
Well, I do have in my notes a proposal from you all that did request a wage increase to 14 for EMTs and 18 for
Right.
paramedics.
Yeah, that was submitted in advance of
Right.
that meeting, yeah.
So, and
With
you
a
mentioned
$1.50 an hour for EMTs and $2 an hour for
For
medics,
supplemental.
yeah.
So that, and I have a discipline article, are those, and I suppose miscellaneous. Those were the 2 proposals
Yeah, we gave you
mentioned.
Article 7 discipline, Article 15 miscellaneous, and the wage proposal that had been submitted electronically prior to our.
Right,
If I remember
okay.
correctly, that was submitted in January,
Yes.
Kristen, if I remember correctly. Yeah.
I received it from Eric, so
Okay.
I didn't receive it
I
directly.
think Mike Jenkins, who was the president of the local at the time, submitted it to Eric in January, I think.
Okay. Just
And
want to make
then
sure I understood.
You had several proposals that you presented to us.
Yes.
On April 9th, and we gave you counters to those proposals.
Article 7 and Article,
No, you presented
15.
proposals on Article 2.
yes, I did. I'm
Yeah.
asking which ones you presented. You said 2.
2,
So that was,
Article 7 and Article 15. And
okay.
then we gave you, toward the end of that session, we gave you our counter proposals to the proposals that you gave us.
I don't have that in writing. I have Article 7, which is dated
Right.
3/7/18, and I have then an Article 7 dated 4/9/19, And Article 15
You don't
dated
have, you don't have our
4/9/19.
counter proposals to you, the proposals that you submitted to us?
I have,
Because my notes reflect that we gave them to you at that session.
I'm telling you what I have. I have dated 4/9, I have an Article 7 and an Article 15.
Yes, those were our proposals to you.
Got it.
On that date, you presented proposals to us.
Yes.
We caucused and developed counters to the proposals that you.
I do not have these, no.
Okay, well, because those are our counters to your proposals.
Good to know. I've not seen these.
Oh, okay, well then, if you want to make copies of those, then we'll maybe caucus so that you can look those over.
Okay.
Because my notes reflect that we did in fact give you, give you those proposals. We gave you our response to your proposals. Okay.
Sorry.
Do you want to see if Kelly can make copies?
7.
7.
2, and then what's the other one, 15?
Well, but
Oh,
these
7.
wouldn't be the most current, so.
Yeah. No, I just wanted to read over and make sure what they currently say again.
It's 2, 7, and 15.
Yeah. Do you have it in writing?
Yeah,
What is
we
it?
presented, yes.
There-
Oh, it went out the door.
Yeah.
We presented two proposals, Article 7 and Article 15.
And that's what I have.
They presented proposals on Article 2, Article 3.
Right.
Article 5.
Right.
18,
Well, right.
well, 19's duration, so there's always. and-
They had a counter on Article 7, Article 18, Article 19, Article 20, and Appendix, no, that was our proposal in Appendix A. And then we caucused and developed counters to their proposals, but somewhere along the line, those guys.
No, actually, I could think it stands out. Colors don't bother me.
So Kristen, do you want to caucus to give your team a chance to look over our counters to your proposals?
If you don't mind.
No, not at all.
All right, JD, can we use your conference room? Okay, thank you.
Is that the same room that we usually caucus in?
Did you want us to go to the other room?
Oh,
Since there's more.
oh.
We'll go,
okay.
we'll go.
A chance to review the counter proposals, and just wanted to get some clarification
All
on a
right.
few things. You could look at Article 2. What was your concern with the last paragraph?
At this point in time, I don't remember. Guys, do you see their proposal, Article 2?
Mhm.
You have that, Renee?
Yes. I think it had to do with the relief employee.
Yeah, a relief position is a reserve position that exists for the benefit of the organization. Relief employees work on an as-needed basis for a limited number of hours each month and are not eligible for employee benefits. Transferring from relief status to full-time status will not be considered a promotion under any circumstances. It's been so long since we talked about what's our objection to that, guys?
Was it some question of employee benefits?
I think it was probably have to do with benefits.
Are relief employees currently eligible for any benefits?
So a certain number of the employee or relief employees are, if they are meeting a certain number of
Some number of hours
hours.
they're eligible for health benefits.
Right.
Well, that's the
And
Affordable
also-
Care Act. I mean, if they work
ACA.
30 hours a week,
Also, I
they, yeah.
think,
which by contract, we can't waive their entitlement to that
Right,
anyway,
no.
so.
And I think it was also, maybe there was some question on their status under the bargaining unit as well. Because I know that further in the articles, there was, we're kind of touching on,
Well, this doesn't call into question their
Right.
place in the bargaining unit.
No.
And as a matter of fact, one of the issues that we have an issue over is Article 7, discipline, where, the county's proposal says that they can appeal discipline up to step 2 of the grievance procedure, and, and our proposal is that they have full access to arbitration. I mean, but this does not call into question their placement in the bargaining unit.
No.
The other benefits thing is relief employees are currently eligible for FRS, is that
What is
the Florida
FRS?
retirement?
Florida retirement.
Yeah, they're,
But again, that's a benefit that's not provided via the collective bargaining agreement. That's a statutory benefit provided by the Florida, Public Employee Retirement Statute. So I don't know that.
I think I understand. I mean, we can work on tightening up the
Yeah,
language.
yeah.
We did just want to make some distinction
Yeah.
and have some sort of definition.
I mean, I think we
Identified.
clearly understand and recognize that relief employees are different than full-time
Right,
employees. That-
right.
Kristen, that's not the problem. I think maybe it was just, it's too broad.
Okay, okay, I understand. I can work on that.
Tighten up.
Okay.
Let's see. I didn't have any questions on 3. Okay, let's go to the grievance procedure.
Give us a number.
Article
That's the
5.
best,
Yeah.
that's the best way for me to keep up.
I mean, most of Article
Page 6,
5
or page
is
6.
in fact agreed to.
Let's see. We will have a new proposal to incorporate, the things from your counter.
Okay.
But before I prepare that, I just wanted to be sure I understand
Okay.
where you're coming from. So you wanted to expand the window to initiate the process and continue the process to 15 days.
Number 3 point, is it 3 what?
One,
You've got it under oral discussion, 15
Right.
days. You've got arbitration, 15 days. And then if you go to the next page, I remember we discussed, I was trying to impose just some sort of time frame to prevent the possibility that if someone has invoked the process, that they're just dragging their feet. And I've had that happen before, not with this union, but with other unions. So, I wasn't trying to impose, crazy timelines and understanding the fact that sometimes it's dictated by the arbitrator, because at times, they may not be so responsive, or it takes them a long time to have, a time when they can
are
schedule.
you talking
it.
about step 3, the arbitration?
Yes.
Yeah.
Letter C? Are you at
So-
C?
Yeah.
Yes.
Yeah.
So, I mean, our counter is the party moving the grievance to arbitration must attempt to schedule.
Mm-hmm.
Because the parties don't have any control over the arbitrator,
No,
obviously.
that's right. But I guess, and I agree with you there, but I would hope they would attempt to schedule. So, with the way the
Right.
process works, you get back
Right.
your selections,
Right.
your candidates, and then you have to contact each other.
Right.
And then strike names.
Right,
And then you send the form back.
right. And then
And
the
you have
arbitrator
to wait
reaches
for the
out to the
arbitrator
parties.
contact
Right,
you.
right.
But I've even had a circumstance where one party, the person typically who moved for arbitration says, I'll return the form. And then you don't hear from the arbitrator, and a month goes by, or 6 weeks goes by, and you're like, well, you said you were gonna send the form in, what happened? Oh gee whiz, I haven't gotten
Well,
around to
I can
that
do
yet.
that,
So
yeah.
that's what I'm
Yeah,
trying to avoid
yeah.
here. But, I can work with you on that,
Okay.
and
Yeah,
see.
and I mean, it doesn't need to, 60 days is obviously, I just wanted to make sure that.
I get it, like sometimes the
Yeah,
arbitrator.
Yeah,
Yeah.
yeah. Yeah.
You know, sometimes
Yeah.
they may not have an opening for 2 months or 3 months.
Yeah,
so-
which is why I said must attempt to schedule, so
Sure.
we, the moving party needs to reach out to the arbitrator.
Yeah,
And if the arbitrator doesn't have any dates or the
Mm-hmm. Understand.
arbitrator fails to respond, I mean, if you send an email
Mm-hmm.
and copy, and we copy you on the email to
Yes.
show that we in fact did reach out to the arbitrator.
Yeah.
But the arbitrator simply hasn't responded.
right, then
That's-
I think we're on
yeah.
the same page there.
And on the earlier steps with the 15 days expansion from 10 days to 15, the only reason is because the employer has 15 days to respond. I mean, the oral thing has to take place within 5 days. We didn't change that. But once that has happened, if it hasn't resolved the issue, having to file the written grievance within 10 days of the occurrence only gives 5 days after the discussion with the oral discussion. 10 days from the end of the time frame for the oral discussion, I think, is more reasonable, hence the total 15 days from the occurrence. Plus, the employer has 15 days to respond at each one of their steps. So it seems fair to have, if the employer has 15 days to respond when they receive a grievance, the union should have 15 days to present the grievance.
We can take that into consideration. So under number 7, so you're proposing that if both parties mutually agree,
To settle the grievance.
well, and my concern and what I was trying to avoid is the circumstance where the grievant may realize, once they really give it some serious consideration, that maybe it's not such a great case, and you're leading up to the hearing date, and you know the arbitrators always have at least a 30-day cancellation time. And there have been circumstances where it's been past that date, despite the fact that I have reminded them, and then they say, oh gee whiz, I think I'm just gonna dismiss this. And then somebody's gotta pay the arbitrator. So in that case, it may be a mutual agreement to toss it out, but they could have done it sooner.
Under those circumstances, it's not really a mutual agreement to toss it out. It's the union saying the grievance doesn't want to go forward any longer. You know, we're going to withdraw the grievance. And then, under those circumstances, obviously,
Well, I
we are
agree.
responsible for but if the arbitration, it's been invoked, you know, the date is approaching, and if I was presenting the case for us and you were presenting for the county, we talk and say, you know what? Seems like there might be a reasonable resolution of this, and we reach a mutual settlement of, then, under those circumstances, it's fair that the parties share the cost of the arbitrator. But if,
I think I can work with you on that.
I've been doing this for 44 years. I don't think I've ever seen an instance where an employer has moved a case to arbitration. It's always the union.
Oh,
that moves.
definitely.
Yeah, so, I mean, if we're the move, well, I mean, I know theoretically an employer could, but 44 years, I've never seen it happen. We're the moving
I should
party.
shock
If
you.
we,
I
if we
understand.
withdraw. Yes, if you did, Janice, believe me, it would shock me to my core. Mike would call me and say, Dick, you're not gonna believe what you said. But, yeah, I mean, I fully understand if we choose to withdraw rather than
Okay.
incur the extra cost of having the hearing and, you know, the
Well,
3 days of
those
the arbitrators.
per
you know,
diem is
per
pretty
diem.
sporty. so-
Oh, yeah, and
Yeah,
you know.
I'm like, really?
If
We
you
owe
hear
you
the hearing, even if
$2,000
it's
for
a
doing
one-day
that?
hearing, you're getting the minimum.
Is it a side gig? Do you have
You're-
that for on a
you're-
side gig?
No, you can't do side gigs like that, no.
Oh, okay.
But, yeah, no,
7
there's,
days of research?
well, no, you get a minimum of 2. You're gonna get a minimum of a
Minimum.
3-day bill
Yeah.
for a one-day
I
hearing.
just got one today for a 7-day research for a 1-day hearing. I was like, you gotta
What?
be kidding me.
Oh, jeez.
Well, it
Now,
sounds
see,
like a
that,
side gig.
that person's trying to build a new retirement. That's what that one is.
Well, under number 8, my intent was only that if the arbitrator doesn't require a court reporter and no one wants to go to the expense, I would think it's a good idea to at least record it. And usually, and that's free, we always have in our facilities recording capabilities, and that way too, it's on record, and if the arbitrator wants to have a copy of the audio, then they have that as well, and it can save costs, because a court reporter is expensive, and, you know, not all of them require it.
You know what? I don't have a problem with that. We
Okay.
can restore the arbitration, as long as you're all right with if the arbitrator requires a transcript.
I think the losing party should pay regardless. That's part of the cost.
You know what? Since we don't really need the transcript, if it's recording, as long as, if we're doing it in one of your facilities and we have access to the audio
Oh, yeah.
recording, I don't care if the arbitrator wants, let them have their own transcript.
Okay.
You know?
Okay.
But the bottom line is, they're not gonna pay for it.
No,
So
they're
how do
not.
we convince the arbitrator? You know what, if it's being recorded, the arbitrator may not require the transcript.
may not.
My problem is if you get a problematic arbitrator who says, no, I prefer to have a court recorder producing a transcript rather than having to listen to the audio tapes.
I've never had
Yeah.
one require.
I'm not sure I
I've had a
have
few say
either.
they preferred it, but in that case, I say, well, then maybe you should pay.
Yeah, okay, all right.
So there's a way to
Okay.
word that, maybe?
Yeah,
Mhm,
yeah.
I think we can
yeah,
work with
I-
that.
Yeah.
Okay.
Again, I wholeheartedly endorse having something other than, you know, the notes, 'cause
Yeah. Some of them fall
I
asleep,
have,
for goodness sake.
unfortunately, he's dead now, but my favorite arbitrator literally would sit in his pen, never left the paper. He literally could do an almost verbatim.
Wow.
He must have really good peripheral vision, because to try
Oh,
and
I
see
know.
your hand
Oh,
doing that while I'm looking at,
It's the most, literally, the pen never lifted from,
that's impressive.
yeah, but, anyway.
In exceptions, what's wrong? Why, did you strike, nothing shall be construed to permit the union to file a grievance on behalf of an employee without his or her consent? Is that an issue?
If something occurs where the union alleges that the contract has been violated, but let's say the employee is in their probationary period, and they don't want to cause waves, but we don't want to let the violation go unchallenged. Since the union is a signatory to the contract, they have the right to grieve a violation of the contract. But if the violation affected only one individual, and that individual doesn't want to file a grievance, I don't think the union should be precluded.
Well, that's what I'm
from grieving
referring
it.
to. I don't mean a situation that could be considered a class grievance.
Uh-huh.
You know, in that case, the union would have standing.
But if it's only one, but.
But if one individual, you know, gets a demotion, or, you know, and they want, or who knows, and they want to.
And I'm not even, if one individual gets a demotion and they don't want to deal with it, we
Why
don't
would
want to
you?
deal, we
Exactly.
don't want to deal with it
That's
either.
all I was talking about.
I just, what I don't want to see happen is a situation occurs, somebody is, bypassed for overtime, or, you know, or something that could happen to other, but in this particular instance, it happened only to one particular employee. So we exercise our right to file what otherwise might be classified as a class action grievance, but there's only, the particular instance being grieved only affected one employee.
Okay.
I don't want language that allows the county to say, well, you can't grieve this because because the adversely affected employee didn't grieve it.
Okay, I can consider that. Probationary period. You guys are gonna help me out with the math on this one and tell me where you're going with it.
Well, because this was the result of the discussion that we had when this came up back on April 9th, and the 2184 is equal to a full-time.
Because full-timers, well, actually, all employees, the way I wrote it, go through 6 months. And then a relief, who then gets to full-time status, would start with a fresh probationary period as a full-timer. It's gonna take a relief employee a really long time to exhaust 2,184 hours.
Right.
I think we clocked it at 10 years.
Yeah, why did we?
If they work their minimum.
If they work their minimum, and we didn't.
I think that in that last conversation, there was some adjustment of those hours. I don't know if that was notated, but I do remember the conversation.
I haven't even seen this.
So.
You're gonna have to catch me up on
Yeah,
that.
'cause
Right, I wanna
I
say
think-
that.
I think 1,092 is
There
equal
we
to
go.
6 months of a full-time employee. So I think maybe
Right.
I
That's what I
think I
remember.
might have intended to do it as 1,092 rather than 2,184. But obviously, a relief employee isn't gonna get, 6 months can't be the.
Because
Okay,
it's relief.
okay, that
correct,
makes sense.
Because it may take them a year.
So you want it to be on-
work, I thought, so.
hours.
Yeah, hours rather than.
Got it.
The calendar months.
Okay, okay. Okay.
Some relief employees a long time to get their $1,000.
All right,
And that's-
we
I
can
mean, that's
consider
on
that
them.
one.
Yeah.
But that was the reason for the change to
Okay.
hours rather than the
Okay.
calendar.
Understand. So, as I said, we will, now that I have the counters, I will revise these articles from our proposal
Okay.
and give you all a counter to these.
Okay,
And I apologize for the disconnect. I don't know how that happened.
Neither
I
do-
honestly can't, it's been a long time, and all I know is that I don't have that in my folder.
and
So-
the only thing I can think of is that we did them, but maybe I got the one was supposed to email them. I don't think so, because my notes reflect.
I know.
That we gave you our response, but
I know I emailed you our electronic proposal after the fact, and then I thought you were going to use that to then make your edits,
that
and I
may,
never
and we may,
got
I may
it.
have given you our
back.
response verbally at the session,
And then never.
I may have dropped the ball and not, obviously, because as I was going through, I went back to that and I said, okay. let
'Cause
me
I can
make
see
sure
where
I-
you've
let me
Yeah,
make
we
sure I
can
had
see
all
where
of
you've
the
incorporated
proposals.
Yeah.
things that you'll see.
So, yeah, I don't know,
That you've
I don't know
already
what
agreed
happened,
to,
but
so.
in any event,
Yeah.
so those articles are not in this batch.
Okay.
But the rest of the articles are. 1, 2, 3, 4, 5.
They might need do you need a sixth for the gentleman that left? Or you'll just use them? Okay.
We'll
Okay.
present copies.
Do you all need any extra
I'm good.
copies? You good? Okay. And if you would like to break and take a chance, or if you want to just skim it and go ahead and sign off on everything, we'll be ready to go.
Why don't we take the caucus, we'll
Okay.
go through them, if we have any, when we reconvene, if we have any questions, we'll,
Okay.
Okay, we're ready.
All right, Kristen, if you could, I will give you our response to your proposals verbally, but if you could email me them electronically, when we break it to Mike and I will go back to the hotel and prepare,
Okay.
written responses and email them to you. But-
Okay, I'll have to create a separate document and extract the articles that I'm working on from the
Okay.
counter, so it'll
Okay.
take me a minute, but I can do
Okay,
that.
yeah, just as if, sometime this afternoon, then we can
No
prepare.
problem.
And actually, since quite a few of them, we're agreeing to them as you propose them, I won't even bother responding, you can just do them up as tentative agreements after.
Okay,
All right, are you ready for our response?
I'm ready.
All right, Article 4. If I don't mention a section, we're in agreement with it. 4.02, the first sentence where you've proposed to delete, the union will be allowed to erect and maintain, and you added in county agrees to provide. It's completely unnecessary because we've already provided the bulletin boards.
That's
They're
fine.
already there. We've already provided them.
No problem.
Then you added 2 sentences, the first of which a copy of each item posted by the union must be provided to the Human Resources Department at least 24 hours before posting. I don't think that's practical. First of all, later on is a provision where the county can remove
Right.
items if they're not, if they aren't appropriate. I mean, if we decide that we need to have an emergency union meeting, and we want to post the notice, and the E-Board decides at 4 o'clock today that they're going to have an emergency meeting tomorrow afternoon, we don't even have 24 hours, to give you the notice. So, and since there is a provision later on that the county can remove any items that we post on the board if the, you know, if they're inappropriate. I don't think there's any need for the sentence that says we provided the human resources 24 hours in advance. The rest of it we're in agreement with. Now, I have a note on 404 where appendix, it should be appendix B, because we did this before we got to your proposal to add the salary, the wage rates into Article 12 rather than as appendix A.
Right.
Understanding that you're proposing, and I don't, excuse me, and we don't have any problem bringing them into Article 12 rather than doing them as an appendix. So my note on that is now no longer necessary because I understand why the change was made to Appendix A. And again, same in 4.06, I had the same thing, appendix, it should be Appendix C, not B, but if we are going to move the salary rates themselves into Article 12, then the change to Appendix B in 4.06 would be fine also. So the only thing that we have an issue with there is the 402, the 24 hours notice.
Got it.
Well, that's assuming based upon your response that maintaining the union will erect and maintain, since
Got
we
it.
already provide that that's acceptable. Article 6, we're fine with your proposal.
Okay.
Article 7. In your counter to us from April, in 7A, you had lined out full-time and just gone with bargaining unit employees shall be, not be disciplined without just cause.
I thought it was clearer to specify because probationary employees are
But pro-
treated
For
different.
probationary is specified at C. I have no problem
Okay.
with your C. My problem is with you reinserting full-time in A.
Well, that
where-
was actually part of the status quo language.
But your counter to us in April, you lined out
Well,
full-time.
this is a new
I-
proposal.
Well, it isn't a new proposal. You already gave us a proposal on this issue.
That doesn't mean I can't give you a different proposal. Do you not
On
think
the-
that this is accurate as stated?
I'm not sure what you mean by accurate. I know that it
What
could
do
be
you take
construed
issue
as
with?
regressive bargaining from your proposal to us in April.
This is the status quo language. What do you take issue with?
The fact is that, first of all, it isn't status quo. The
Well,
C,
it
the
says
C doesn't exist
full-time.
currently.
I mean,
Yeah,
full-time.
right, yes. But you gave us a proposal in April in which you accepted our proposal in A, lining out full-time. We gave you a proposal eliminating the word full-time. In April, you gave us a counter to that and agreed to line out.
We haven't reached a tentative agreement on this.
I understand that, but
Can you tell me what you take issue with?
the fact that you have restored full-time in A after agreeing to delete it.
We
in
haven't
April.
reached a tentative
We may
agreement
not have
even
reached a
on
tentative
this
agreement, but you
article.
made a you accepted
We're gonna have
that
to get off,
element
we're
of our
gonna have to, we're
proposal.
gonna have to move on. Can you tell me what you take exception with?
We take exception to full-time in that, in
Why?
A. Because we don't think relief employees shouldn't be entitled to the just cause protection. We don't think relief employees, we don't think the county should not be required to have just cause to discipline relief employees, whether they're, if they're in the bargaining unit, whether they're full-time or relief, they should be entitled to the same just cause protection, whether they're full-time or relief or part-time or whatever phraseology is used to describe less than full-time employees.
Okay, I understand your position. We will discuss it.
All right. And we are in agreement with the C that you
Okay.
proposed. That's fine. We
Okay.
understand.
Got
But
it.
we are also proposing to delete B as we did in our original proposal to you. Not limit the right of appeal for relief employees to step 2 of the grievance procedure.
I understand.
Article 8, we are okay with your proposal.
Okay,
Article 9, we are okay with your proposal.
Alrighty.
Article 10, we are okay with your proposal. Article 11, we are okay with your proposal.
Okay.
Article 12, we are not okay with your proposal, we have a proposal on wages. I don't
Oh,
think, I don't think that
man.
comes as a shock to you that we don't.
No, that's okay.
I thought you were
yeah.
gonna.
And I wanted to clarify, this is intended to represent the
The
base.
yes, yeah.
The base rate.
No, understood, I mean,
Not
it's
with the
what the,
3%.
yeah, it's what the current rates are, yes.
Yes.
Article 13, we're okay with your proposal. Article 14, my understanding is that relief employees are currently in the in the FRS retirement system. The way I read your proposal is that it would only be full-time employees who are included in that.
If they are, then we can make that clarification. And I
They
don't
are.
know
Obviously,
the
I'm not-
answer to
I'm not,
that.
obviously, I'm not familiar
are,
with the
Nikki.
Florida retirement system.
All of them are? Okay, then
Okay.
yes.
All right,
We'll just say eligible bargaining unit members.
okay. Then we're good with that also.
Okay.
Article 15, 1501, 2, and 3, we're fine with your proposals. 1504, we want to maintain the current language. We want to maintain shift swaps.
All right.
And Article 15, Section 1506, we are okay, but we want to continue to provide that attendance at county-provided classes shall be paid as hours worked, as we did in our original proposal on that.
Okay. Okay.
And I was gonna say that the proposal we originally made to you, but because you said all classes necessary to maintain certification, our language where it said including but not limited to, and it specified the classes.
All the
That's
classes.
not necessary, because your proposal said all of the classes necessary, which is the reason why I didn't respond with our original proposal to you, but we do wanna maintain the provision that for the county-provided classes, employees shall be paid. If the county can't provide the class or doesn't provide the class, and you pay for the class elsewhere, we're not proposing that you pay for attendance at that class, only at the county-provided classes. Article 16, we're okay with that. Article 17, we're okay with your proposal. Article 19, depending on what we do with wages, I mean, if we're gonna do a 3-year contract, I'm not sure we wanna deal with wage reopeners again, I mean, but the duration's gonna depend on what we do
Yeah.
with.
Wait, I'm sorry, you said you were okay with 17 and 18?
17,
That's what I did, I wanted to make sure.
you didn't have an 18.
Oh, sorry.
Yeah.
Okay.
And 19, yeah, 16 and 17.
Okay.
19 is duration.
Yes.
And since you've, deleted the references to reopeners, and we don't want to agree now that we'll agree to a 3-year contract if we can't agree to
Right.
wages for 3 years.
Understood.
So
Understood.
the term is contingent upon what we do.
Okay.
I understand.
So it looks like I only have to prepare a couple of counters to you because we've accepted
Okay.
the overwhelming majority. But if you could send the ones that aren't tentatively agreed,
Yes.
okay? And we will then,
So let's just review. We've got,
Article 4 is not tentatively agreed.
okay,
And the only thing there is 4.02.
2, okay,
Article 6 is okay, is agreed to. Article 7, we have issue with, so.
okay. So we've got 4.
And actually, you don't need to send me that, because
You think you can tap that one up?
yeah, it's only one sentence. I think I can take our original proposal to
Okay.
you and add C to it, and it's not an issue.
Okay,
Article 8, we're agreed with. Article 9, we're agreed with. Article 10, we're in agreement with. As we are with Article 11. Article 12, obviously, we have agreed to that. 13, we're agreed to. 14, we need to, you're gonna make an amendment there to
Yes.
reflect, okay. Article 15,
Okay, you need 15.
yeah, I need 15.
Okay,
16 is agreed to, 17 is agreed to, and 19, I'm not gonna give you a counter on 19 yet, let's just leave it that way.
No
It's
problem.
subject to what we do with waivers.
okay,
So basically, it's 4, I don't need 7, because I can do that.
Okay.
And 15.
okay. 4 and 15, I
And
can do
then
that.
I will, when Mike and I get back to the hotel, we will do counters and email them to you, so you will have them before we begin tomorrow morning.
Okay, that
All
sounds
right.
great. And we will have our counters, we'll probably have them tomorrow morning.
That's fine.
On the others.
That's fine.
Okay.
Do we need to meet earlier? Us, do we need to meet earlier?
Yes.
Yeah. That's what I
So,
figured. So we can meet for breakfast tomorrow.
okay, you can meet. So,
Is there anything else?
No, it's probably end for today, and then we'll go back, as soon as you send us those, we'll
Okay.
do the